Greetings, Attorney Derek DeBrosse, coming to you guys from Columbus, Ohio, Munitions Law Group, munitionsgroup.com, munitionsgroup.com. Please go ahead and subscribe to our channel, drop a comment in the box, click that little bell icon so you get updates when we produce new videos for you guys. Today was not a scheduled video, but I wanted to talk to you guys today, specifically the viewers from Ohio. Governor DeWine yesterday, I believe it was yesterday, signed Senate Bill 215 into law, which takes effect sometime in July. That is what's referred to commonly as constitutional carry. There's a lack of a license necessary to carry in the state of Ohio. So I have some notes here I wanted to go through, but before I do that, I wanted to talk a little bit about the history of constitutional carry. It's not the first attempt to try and get it passed, and I was getting asked for the last 30 days or so, is Governor DeWine going to sign it? Is Governor DeWine going to sign it? Many of you may remember, I think it was about a year or two ago, I can't really recall when the shooting in Dayton happened. Adam, do you remember? There was a shooting in Dayton. It was an active killer down there, I think, in the Oregon district, if I remember correctly, at a bar. And nevertheless, the point of that is that Governor DeWine came out after that tragedy and was really pushing very much so for red flag laws, different types of gun control. Which not necessarily was a surprise to most of us gun owners in Ohio. DeWine's always kind of had two different identities when it comes to guns, and it's been a real struggle with him politically. So I was fairly confident he would sign this bill, and I guess I was proven right. As you all know, politics is just a roll of the dice, so I could have just as easily been wrong. But for those of you that are gun owners that like constitutional carry and what it brings with it, this is good news. So I wanted to go over today, just in my estimation, I read through it twice this morning. I've had my staff read through it, and I wanted to go over some of the highlights of what that law does. So again, it's Senate Bill 215. It should take effect sometime in July. So the first thing it does is it creates some new definitions, which are very important to the law. The first definition it creates of any import is known as a restricted firearm, quote unquote. And it's defined as basically dangerous ordnance or any other firearm that's not legal in the state of Ohio. Dangerous ordnance are traditionally your National Firearms Act regulated firearms. Now they can be legally owned in Ohio, but you have to have a specific license for them. So fully automatic machine gun would be an example of that, short-barreled rifle, short-barreled shotgun, things like that. So the constitutional carry law would not permit you to carry on your person concealed without a license a fully automatic machine gun. That's very clear, or even a suppressor, for instance. So again, the new definition is restricted firearms. The law talks about restricted firearms. Number two, it creates a definition for what we call, or what the law now calls, qualifying adult. It's basically anybody who is an adult who's 21 years or older and is eligible to have a concealed handgun license in Ohio. So that would bring with it certain convictions, would disqualify you from that. What I normally tell people, because the law recites the certain statutory code provisions as to what the criminal background would be that would preclude you from having that license, I kind of summarize it into any type of felony, anything violent, anything drug related, you probably are going to have an issue. Now it's obviously a lot more narrow and focused than that, so if you guys think you may have a problem with it, you can always give our office a call and we can look at it and try to fix the issue for you. So those are the two main definitions you really need to focus on in Senate Bill 215. So what does the law say from there? Well, regarding qualified adult, basically what the law says, if you are a qualified adult, again 21 years or older, otherwise qualified for an Ohio concealed handgun license, you can carry in the same places as a concealed handgun licensee would. Essentially what the General Assembly did in Ohio was take the concealed carry licensing statute and apply it to anybody who's 21 years or older, again a qualified adult, and say if you're a qualified adult and you want to carry a concealed handgun, all those concealed handgun laws apply as they would if you were a licensee. That's essentially what the law did. So again, the same restrictions apply to a qualified adult as they would apply to a licensee. Like you can't drink alcohol in a bar and have a concealed handgun on you, right? That wouldn't qualify. If you become disqualified or a disqualified adult, it's an immediate revocation. There's no hearing or anything. You just can't carry concealed anymore if you end up getting a criminal record that would have otherwise precluded you from having a concealed handgun license under the licensing scheme in Ohio. It also did another very big change we've been pushing for a while in Ohio. It's not, in my estimation, perfect, but it's an improvement. and that is the duty to notify. I think Ohio is one of 6 states that has had that on the books. And the law used to say when you were stopped, it's again a legal term of art, the word stop means essentially a Terry stop, stop for an investigation for a law enforcement purpose. You must promptly notify the officer if you are armed and are a licensee. So we got rid of the word prompt, so that's no longer there because that was always unclear as to what that meant, how fast it needed to be. And what the law essentially says now is that, I'm going to quote this to you actually because it's of everything in this bill, this is the worst part in the sense of how it's written because it's somewhat vague. I shouldn't say very, it's somewhat vague. And here's what it basically says. Before or at the time a law enforcement officer asks if the person is carrying a concealed handgun, knowingly fail to disclose. So what the law is saying that nobody shall, before or at the time a law enforcement officer asks if the person is carrying a concealed handgun, knowingly fail to disclose. So if you flip that on its head, you must disclose at the time you're asked or before the time you're asked. So it begs the question, what if they never ask? I went around in the office on this trying to figure out, well, do you have to notify if they don't ask? My conclusion after reading the bill analysis and after just thinking about this logically is no. Now again, there's no case law on this, hasn't even taken effect yet. But why else would they have this? And there wouldn't have been any change in the law at all. So the legislative intent clearly was you have to be asked in order to have the obligation to notify. And it doesn't say you must promptly notify, it says you must disclose it. So if the officer asked, you would disclose it. Moreover, let's say an officer doesn't ask. Well, it's still before they ask, so you're not technically violating the law as written. Again, just very poorly drafted in my estimation, but nevertheless, that's what the law now says, is that you essentially only have to notify if you're asked by a law enforcement officer. If any of you out there have received a conviction for failing to promptly notify, you can now get that expunged, okay? And it's not just a sealing of the record. This bill, Senate Bill 215, allows you to actually expunge it in Ohio, which is rare, meaning they will shred it, burn it, tear it up, it's gone. It's not just sealed, it's actually expunged. They changed the penalty for failing to disclose if you are armed when you're asked by a law enforcement officer from a first-degree misdemeanor to a second degree. For most of us, it's insignificant because it's all going to be negotiated anyways if you're charged with it. But it is a reduction in the maximum possible time you can do in jail. I think it's 5 months versus 6 or 4 months. It's a matter of months. It's not a substantial amount of time, but it is a change in the amount of time you can do. And then lastly, if you have a concealed handgun license, you don't have to have the physical license with you anymore. That was always kind of a weird nebulous thing in the law that you had to have this license on you. So what are the benefits to having the license? I've been able to pinpoint 2 primary benefits. One, if it was issued after the requisite date as designated by the ATF, which was in March, I think 2017. So most of us should have had that issued by now, have a license that's after that date. You can buy a firearm from a licensed dealer at the federal level without going through a NICS background check because that license is proof that you're qualified to have a gun. And then obviously, number 2, for reciprocity in other states. But I just wanted to get this information out to everybody. I know it's a brand new law. There's been a lot of questions as to what this bill does. And it's sort of a behemoth. It's 33 pages long, but when you actually get down to the nitty-gritty of it, there's not a ton of changes. So I encourage you guys to read it. Just Google it, you'll find it. And as always, feel free to reach out. If I'm wrong on anything, feel free to drop a comment, call me, shoot me an email. I'll be more than happy to correct it, but I think I'm reading the law correctly. So again, thank you guys for watching. Please drop comments, keep following us, and as always, be safe and carry on.